Both the writ petitions are dismissed.
Lordship.
I'll sign the other pages here. Signature later, okay? 1 minute.
Make me, my lord,
Yes, 1 minute.
lordship. I pray that
Yes.
I pray that allow me to move to unlisted motion, that is COP. We have filed before and everything is ready. However, the new CS is impleaded, and since his effective date is today, it has been kept, and only today it has been entered. COP.
It's okay, you move it on Monday.
There is one
Because there's no urgency. No, as far
There
as-
is one aspect, Lordship. Monday, this they have filed an appeal before the Gauhati High Court, and it is coming up on Monday. So, just prior to that, I just want to let this contempt
Otherwise, it's already filed.
already. Everything is ready, except that the CS effective date of taking over charge officially is today, with effect from 1st. That's why it was kept pending.
Okay. Because I just call, okay? Okay, yes, and when it comes.
2. Obliged, Lordship.
May I please, Your Lordship? I beg to mention item number 4, Lordship. Petition item number 4. I am for private respondent number 4, Lordship. I have sent for the waiting and I'm still yet to receive the affidavit that has been drafted and sent. So I will be allowed 2 weeks' time, Lordship.
2 weeks.
Lordship.
Heard Ms. Apila Sangtam for the respondent number 4, who submits that she has sent the affidavit in opposition for vetting and signature, and accordingly prays for 2 weeks' time to file the same. Learned counsel for the petitioner has no objection. Learned Government Advocate Mr. M. Lonkoma is present. Please the matter after 2 weeks.
Obliged, Lordship.
May I please, Your Honor? I beg to mention item 6 on behalf of Government Advocate S. Chang. We pray for 2 weeks to file an affidavit.
Yes. Learned Government Advocate M. Lonkoma praying on behalf of Government Advocate S. Chang submits that they may be given 2 weeks' time, prays that they may be given 2 weeks' time to file the affidavit in opposition on behalf of the state respondents. Learned counsel for the petitioner is present. Learned counsel such for respondent number 5 is present. List after 2 weeks. Yes.
Obliged.
My Lord, please allow me to mention item 5 on behalf of the counsel for the respondent. On his instruction, I paid the matter bill. He said after 2 weeks, he will be filing affidavit in opposition for all the respondents.
Okay. This Z. Kurno. Prayer has been made on behalf of Learned Counsel Z. Kurno for the respondents, praying for 2 weeks. 2 weeks.
2 weeks.
3 weeks or 2 weeks?
2 weeks,
Praying
not 3
for
weeks.
3 weeks' time to file affidavit in opposition. So, Learned Counsel for the petitioner is present. List after 3
Lordship,
weeks.
this interim order may be continued.
Yes. The interim order passed earlier shall continue till the next date. Yes.
And my Lord, item 8 on behalf of A. Nikatukosa, the learned counsel for the petitioner. My Lord, on his instruction and prayer, he is on the way. So if the matter may be taken up after a regular matter are listed.
Okay, call after something. Yes.
Hello, Lord.
May I please, Your Lordship? Your Lordship, I beg to mention item number 7.
7.
Yes, Your Lordship. Your Lordship, we are yet to file our reply, so please grant us 3 weeks.
Reply to the government affidavit.
Yes, Your Lordship.
Heard Learned Counsel Ms. R. Atsela Gibbs for the petitioner, who prays for 2 weeks' time to file a reply to the counter affidavit filed by the state respondents. So, Learned Government Advocate M. Lonkoma is present. Prayer is allowed. List after 2 weeks.
Much Your Lordship.
For motion from the supplementary cost list, item number 11.
May I please, Your Lordship?
Yes.
Lordship, here, respondent number 1, it is Chief Secretary. We have come to learn that he has been retired on superannuation, and respondent number 4 has been appointed as the new Chief Secretary with effect from today, that is date 1 August 2025. So, Lordship, here, if you may kindly please.
Even respondent number 3 has changed. The Home Commissioner is transferred out. So one, just who's appearing otherwise? Anyone appearing
On behalf of
on behalf of the respondents? Anyone appearing?
Yes, Lordship.
Respondent 3 is also transferred out, isn't it? Home Department. Mr. Vyasan R. You just take instructions. I think you have to change 1, 3, and 4. Learned counsel for the petitioner prays that he may be given some time to file an IA for impeachment of the new Chief Secretary and new Finance Commissioner. That is respondent number 1 and 4. Prayers allowed. List after 1 week.
2 weeks.
List after 2 weeks.
Much obliged.
For admission, item number 3.
Or what you can do is, excuse me, you can withdraw this and file afresh.
They can do.
Yes, that is better. You file, learned counsel, you delete that whole thing. Learned counsel is allowed to withdraw the petition with liberty to file afresh. Yes.
Much obliged.
May I please, Your Lordship? This instant IA is filed for impleadment of respondent number 3, the Principal Secretary, Department of Environment, Forest and Climate Change, Sri E. Mhombemo Patton, IA and AS. Since the respondent number 1, Smriti R. Asinlakitsar, IAS, Commissioner and Secretary has retired. So if the Lordship may kindly be pleased to allow to implead Sri E. Mhombemo Patton as respondent number 3 in the contempt petition.
Learned counsel for the petitioner, and such and such. So, this is an application praying for impleadment of Sri E. Mhombemo Patton, Principal Secretary to Government of Nagaland, Department of Environment, Forest and Climate Change, as respondent number 3 in COP's 3 of 2025. Stop. Para. Learned counsel submits that in the COP 3 of 2025, the respondent number 1 has retired in the month of November, and Sri E. Mhombemo Patton has taken charge as the Principal Secretary to Government of Nagaland, Department of Environment, Forest and Climate Change. Stop. And by this court's order dated 28/7/2025, the petitioners were allowed to take necessary steps to implead the newly appointed incumbent. Stop.
Lordship, COP 12.
COP 12.
Yes, Lordship.
But in your petition it is written COP 3. COP 12 then, not 3. See your course title, application under such and such for impleadment of necessary party in COP 3. But again at para 1 you have written 12. Yeah, just say 12. You correct the course title. So accordingly, this application is allowed. The petitioner shall file the recast cost title.
Your Lordship, let the notice go, because
No, after that notice will go. After it's impleted, then notice will go.
okay.
Obviously, yes. Such as respondent number 3. And the petitioner shall file the recast cost title accordingly.
For hearing, item numbers 9 and 7.
Why is this?
Yes, Lordship.
Yes.
The facts and the question of law involved in item number 9 and 10 are sent.
No.
Therefore, Lordship, I'm relying on item number 10, WBC 238.
238.
So before I refer to the documents in my writ petition, Lordship, short text is that, Lordship,
1 minute. WPC 238. Yes.
the petitioner was placed under suspension on 2/10/2018 in view of registration of a criminal case. His suspension was revoked on 13/3/2020 after 17 months. Now, during the suspension, Your Lordship knows the petitioner received a subsistence allowance. Now, the only barrier in this writ petition is the petitioner is praying for to grant the area 50% of the salary, which was not paid during suspension.
During the
period.
suspension.
So that is the only issue of this writ petition. Lordship, we kindly come to my writ petition 238. How the criminal case was registered and how the disciplinary proceeding was initiated against the petitioner. I am referring to 3 paragraphs only, Lordship. Paragraph 3.
Yes.
That there was a dispute pertaining to a loan and recovery thereof between the petitioner and one Delactas and Niraj Paswan, who were distant relatives, including one Mahavir Paswan, the petitioner in the other petition, Mahavir Paswan, of police proceeding, resulted in filing of a complaint by one Niraj Paswan against the petitioner and who accused Mahavir Paswan. Based on the FIR, a criminal case was registered against the petitioner and other being Kohima Scout base case number so under section. That based on the frivolous complaint and the registration of the criminal case, herein by order of 10/2018, the petitioner was placed under suspension with immediate effect. Next, paragraph 5 proceed. That after the petitioner was placed under suspension, disciplinary proceeding was also initiated. On completion of the proceeding, based on the report submitted by the inquiry officer by order dated 13/3/2020, petitioner was reinstated in service. By the said reinstatement order, the petitioner has been imposed a penalty of withholding of increment for 2 years with cumulative effect. It is also provided that the period of suspension till reinstatement is treated as such, not with those who pay allowances, but without break of service for the pensioner. Paragraph 6. That the criminal case registered against the petitioner was tried by the Judicial Magistrate First Class, Kohima NGR case number so and by order dated 30/4/2024, the petitioner was discharged from the criminal liabilities of the charges, holding that there is no ground for presuming the commission of offence charged against the petitioner. That is the facts. How the petitioner was suspension and how he was reinstated. So, if we kindly come to annexure suspension order.
Page
Page 1 313, Lordship.
Page 13. Yes.
How he was suspended is very important, Lordship. Whereas a criminal proceeding, Lordship, in view of registration of the criminal case, he was placed under suspension. Whereas a criminal proceeding against Constable Driver so Nagaland is contemplated for committing illegal activities by involving an illegal gratification when he was arrested on so. Now, therefore, the undersigned in exercise of power conferred under the role, soft role of Nagaland Service Discipline and Labor Rules 1967, hereby placed Constable so under suspension with immediate effect. It is further ordered that during the period that this order shall remain in force, the order of the Constable Driver shall be the office of the Director General Office HQ and the said Constable Driver shall not leave the headquarters without obtaining permission of the Assistant Inspector General of Police. During the period of suspension, Constable will be entitled to subsistence allowance at an amount equal to that's not necessary, Lordship. So during the suspension period, I've been paid only subsistence allowance. Grab the next page, Lordship. This is the reinstatement. May I have Lordship? This order dated 13/3/2020.
Page 14.
Yes.
Yes.
Whereas an order placing Constable Driver Sunil Suinso under suspension by Suinso, and whereas a disciplinary proceeding was initiated against the delinquent by framing article of charges, by appointing inquiry officer and presiding officer to inquire into charges against him. The inquiry officer has submitted the report where the charge framed against the delinquent found proven. The undersigned issued a memorandum that the Suinso proposed a major penalty of dismissal from service to be imposed on the delinquent. And whereas the delinquent and his reply to the memo has submitted a representation on the proposed penalty on him. Now, therefore, the undersigned in exercise of moral comfort by Rule 7 Clause 4 of Nagaland Service Discipline and Labor Rules 1967 hereby impose the penalty of withholding of increment for 2 years with cumulative effect and reinstate him in service with immediate effect. The period of suspension will be till reinstatement is treated as such, not entitled for payment and allowances but without break of service for pensioner. 2 penalty was imposed by this reinstatement order. First, Lordship will withholding up to increments for 2 years, increments for 2 years, and it has been ordered that suspension till reinstatement is treated as such, not entitled for pay and allowances. After reinstatement, Lordship, what happened, Lordship? This reinstatement order was based on the finding of the disciplinary proceeding. Now, next page, Lordship. At the time of reinstating the petitioner, the criminal case was pending before the Chief Judicial Magistrate, first class. Page 15 is the order passed by the court below, Lordship. This is order dated page 15. 34/2024. Order 1. The accused person de la class Suinso and Suinso are present before this court with learned counsel Suinso. The learned ABB Suinso is present on behalf of the state. Duty is fixed for CC of 3 accused persons. Learned ABB submits to address a prima facie case against accused Suinso for committing forgery of the appointment order of Vijay Kumar, hence attracting the charge under section 465 ABC, and that there is prima facie case against Mahabir Paswan for cheating the co-accused Suinso of rupees 2 lakhs by offering him a government job and IRB under Nagaland Police, thereby attracting the offense under Section 420 IBC. She further submits that the accused persons are all government servants and have received a legal gratification as such. The offense under Section 13 of the Prevention of Corruption Act 1988 is attracted against all of them. She does plead for further charge under Section 13 of the Prevention of Corruption Act against all the accused persons. Section 465 IBC against Suisu and Section 420 IBC against Mahabir Baswa. Learned counsel for the accused person submits that the ingredients of the offense are not made out against the accused person, but both the parties. Records used that the FIR was lodged by Niraj Paswan, who was later added as co-accused in the present case, in charge with Section 171 EIVC. The result of the charge sheet shows that the charge sheet is purely based on the statement, admission of the accused person during police interrogation, and there are no independent findings of the IU. The result of the statement of the informant, SI Swinso under Section 161, CRPC shows that the same is based on the finding of the inquiry officer made in his inquiry. The report of the inquiry officer, April Swinso, reflects that one Swinso Prasad had lent money to Niraj.
No, but what has the criminal proceedings got to do with the disciplinary proceedings?
Lordship, no, it is settled principle of law that when both the proceedings, that is disciplinary proceeding and the criminal proceedings, are based on same facts, the finding of the disciplinary proceeding cannot stand. That is the law, principle law, Lordship.
Same facts.
Same
disciplinary
facts, Lordship.
proceeding also.
Same facts. Therefore, my submission and my cases, Lordship, in view of the discharge of the petitioner from the criminal liabilities.
On what ground it was discharged?
Yes, paragraph 8, Lordship.
Just see the
Lordship.
observation of the court.
Resolution to follow up change.
14, paragraph 14.
Yes. Thus, upon considering the police report and the accompanying materials and examination of the accused person, and after hearing both the parties, this court considered the charges against the accused person to be groundless and deemed it fit to discharge the accused person under Section 229 CRPC. As there is no ground for presuming the commission of offense charge cases.
Okay, so at CC stage they were discharged.
Yes. There was no ground to proceed with the criminal case, Lordship. And accordingly, they were discharged.
And punishment in the disciplinary proceeding was given as withholding of increment for 2 years.
Yes. And in the disciplinary lordship, may kindly come to paragraph 12 of my petition. Paragraph 12. That is my second case, lordship, prayer. I made a prayer in my petition also. Paragraph 12.
Yes.
Apart from the areas, lordship. That the petitioner begs to state that by the reinstatement order dated 13/3/2020, penalty of withholding of increment for 2 years has been imposed with cumulative effect. However, despite lapse of 4 years, the respondents are making deduction of more than rupees 2,000 per month till date, which is contrary to the reinstatement order. As such, the petitioner is entitled for the recovery of deduction after lapse of 2 years, as stated in the reinstatement order. In the reinstatement order, lordship, only 2 years increment was made. However, at the time, till date, respondents is deducting more than 2,000 every month, lordship. And this statement made in paragraph 12.
Till now.
Yes.
2020, 21, 22, 23, 25. It's now for 5
My
years.
statement at paragraph 12 has not been contributed by the respondent, which amount to admission. No justification, no reply to paragraph 12, lordship. And prayer has also been met. Lordship may kindly come to prayer number 3. Apart from the other areas, Lordship. Direct the respondent authorities to restore the agreement and to pay the deducted amount beyond 13/3/2022. So my
Give some authorities regarding
yes,
this
my only case is, Lordship.
same ground.
Yes, when the proceeding of both the criminal and the civil proceeding is based on the same facts,
The same
the
facts.
finding of the disciplinary proceeding cannot stand. Lordship, I am relying on 4 judgments. First, Lordship, 1999 3 ACC 679, paragraph 2 to 9, 34 and 35. Two to 9 are all facts, Lordship. So I'm reading from paragraph 2,
1999,
are facts, 34 and 35.
34 and 35.
2 to 9, 34 and 35. Yes, Lordship.
Yes.
Paragraph 2. Whether development proceeding and the proceeding in a criminal case launched on the basis of the same set of facts can be continued simultaneously is a question which drops up very narrowly in service matters and has once again arisen in this case in the following circumstances. Paragraph 3. Bharat Coal Mine Limited Situation Respondent number 1 as the government undertaking at Suisu and Karnataka, where the appellant was appointed as security officer on 31/1983. On 2/6/1985, a raid was conducted by the civilian police at the house of the appellant from where a mining Suisu with thing of Suisu grams of gold bearing sand were recovered. Thereafter, on the same day, a provisional report was lodged at the police station and a criminal case was registered against the appellant, who was placed under suspension on 3/6/85. The next day, namely on 4/6/1985, a charge sheet was issued proposing a regular criminal inquiry with regard to recovery of above articles from his house. On Suisu, the appellant made a resolution to discipline authority denying the allegation made against him. The charge sheet pleaded that the entire episode was a concoction. It read that the criminal proceeding initiated against him may be dropped or me, and the alternative be postponed until the conclusion of the criminal proceeding against him on the basis of the first information report lodged against him at the police station on Suisu. The resolution was rejected on Suisu, and the appellant was informed that the disciplinary proceeding would be held against him on Suisu. 4. In the meantime, the appellant filed with petition number Suisu and Suisu High Court for direction to restrain the respondent from proceeding with the disciplinary proceeding till the conclusion of the criminal case, as the appellant defense was likely to be prejudiced. The writ petition was disposed of by the High Court on Suisu, and a direction was issued to the respondent to consider dispose of the appellant in a bill filed against the order of suspension, but liberty was given to the respondents to defer the disciplinary proceeding if it was found expedient to do so. The respondent did not defer the criminal proceeding and continued the proceeding which the appellant could not attend on account of his ill health and financial difficulties which permitted him to shift to his hometown and Guerrilla. Respondents were informed by a number of letters supported by medical certificate about his illness with a request for staying the criminal proceeding and with the result of the criminal case, but the inquiry officer rejected the request and recorded his finding on Suisu, holding the appellant guilty. These findings were accepted by the disciplinary authority, and by order of the Suisu, appellant was dismissed from service. On Suisu, judgment and the criminal case was pronounced, and the appellant was acquitted with a categorical finding that the prosecution had failed to establish its case. The judgment was communicated by the appellant to the respondent number so on with a request that MEB be reinstated, but the respondent by later dated rejected the request on the ground that the appellant had already been dismissed from service on inabilitation of the tribunal inquiry, which was conducted independently of criminal case, and therefore the judgment passed by the magistrate was of no consequence. The order of dismissal passed by the respondent was challenged in the criminal appeal, which was considered by the appellate. It was at this stage the appellant approached the High Court through a writ petition under Article 36 of the Constitution, challenging the validity of the order of dismissal on various grounds, including that the tribunal proceeding based on the same set of facts on which the criminal case was launched against him ought to have been stated awaiting the result of the criminal case. It was also pointed out that since the appellant had already been acquitted and the prosecution case against the appellant based on the raid and recovery, which also constituted the basis of the criminal proceeding, had not been found to be true, he was entitled to be reinstated in service. The writ petition was allowed by the single judge of the High Court on so with a finding that a criminal proceeding and the criminal case being based on the same set of facts, the criminal proceedings should have been stayed till the result of the criminal case. And since in the criminal case the appellant had already been acquitted and the prosecution case was not found established, the respondent could not legally refuse reinstatement or the consequent back wages to the appellant. While directing the reinstatement of the appellant, the High Court gave liberty to the respondents to initiate fresh proceedings against the appellant after perusing the judgment passed in the criminal case. Next, paragraph 9. The judgment was, however, set aside by the division bench on or later and it is this judgment which is appealed before us. Which may kindly come to paragraph 34. That's what she called it. Paragraph 34.
Yes.
There is yet another reason for discarding the whole of the case of the respondent. As pointed out earlier, the criminal case as also the criminal proceeding were based on the identical set of facts, namely the writ conducted at the appellant proceedings and recovery of ingredient articles therefrom. The finding recorded by the inquiry officer, a copy of the appellant was copy of which has been placed before us, indicates that the charges framed against the appellant were sought to be proved by the police officer and bench witnesses who had raided the house of the appellant and had effected recovery. We were the only witnesses examined by the inquiry officer, and the inquiry officer, relying upon their statement, came to the conclusion that the charges were established against the appellant. The same witnesses were examined in the criminal case, but the court, on consideration of the entire evidence, came to the conclusion that no search was conducted, nor was any recovery made from the residence of the appellant. The whole case of the prosecution was thrown out and the appellant was acquitted. In this situation, therefore, where the appellant prosecution was thrown out and appellant was acquitted. In this situation, therefore, the appellant is acquitted by the judicial pronouncement with the finding that writ and recovery at the residence of the appellant were not proved. It would be unjust, unfair, and rather abusive to allow the finding reported at the ex-party criminal proceeding to stand. Since the facts and evidence of both the proceeding, namely the criminal proceeding and the criminal case, were the same without there being any iota of difference, the distinction which is usually drawn as between the criminal proceeding and the criminal case on the basis of approach and burden of proof would not be applicable to the extant case. Also, plus, I'm reading paragraph 36 also. For the reason stated above, the bill is allowed. The impugned judgment and order passed by the division bench of the High Court is set aside set aside, and that of the learned single judge, insofar as it purports to allow the writ petition is upheld. The learned single judge has also given a liberty to the respondents to initiate fresh disciplinary proceeding. In the particular circumstances of the case, especially having regard to the fact that appellant is undergoing his acquittal since 1985, despite having been acquitted by the criminal court in 1987, we would not direct any fresh governmental inquiry to be instituted against him on the same set of facts. The appellant shall be reinstated forthwith on the post of so and shall also be paid the entire error subsidiary, together with the allowances from the date of suspension till his reinstatement. Within 3 months, the appellant would also be entitled to cost which is so. So in this case, Lordship, both the proceeding were paid based on the same set of facts. In the present case also, Lordship, the disciplinary proceeding and the criminal proceeding are based on the same facts, Lordship. Therefore, the order passed in the criminal case will prevail. Next citation, Lordship, 2024 1 ACC 175. (2024) 1 ACC 175. Paragraph 1 to 7. Paragraph 11, 12, 28 to 30, and 34. So, paragraph 1 to 7. Paragraph 1. These are the facts. Lieutenant Ramlal Singh was a constable with Rajasthan Armed Services 19 Battalion Services. He was appointed on 15/12/1991. Our first information report was registered on 2/9/2022 against him under Section 420 Services. Soon thereafter, on 2/4/2003, it should be 23. A charge sheet and a November inquiry was also issued. The identical allegation in both the proceedings was that the appellant altered his date of birth from so to so. In his 8th started mark sheet, it was alleged that this was done to project himself as having attained maturity at the time of recruitment. The appellant denied the charges. Asked about the overriding in the application, the appellant stated that it was possible that in the application form it might have written initially as so and thereafter they corrected it to so. He, however, maintained that his date of birth is so. Paragraph 4. 5 witnesses were examined in the criminal proceeding. These very 5 witnesses were also examined in the criminal trial, apart from 8 other witnesses who were also examined at the criminal trial. The inquiry officer in the criminal proceeding found that the charges proof and disciplinary authority by order to dismiss the appellant from service. The appellant authority also dismissed the appellant. Attempts to have the order reviewed and the penalty reconsidered were also in vain. At the criminal trial, the trial court convicted the appellant for offence under Section so and sentenced him to undergo 3 years imprisonment along with fine of the social. However, the additional district and session judge so by judgment that so allowed the criminal again to be acquitted the appellant. Paragraph 6. The appellant thereafter represented for his statement. Subsequently, he filed a writ petition in August 2008 for quashing the dismissal order that is so. The order of the appellant authority and the order refusing to review. We consider the opposite orders. Paragraph 7. The learned single judge by judgment dated 13/8/2008 dismissed the writ petition by holding that standard of proof in a criminal proceeding and the criminal proceeding is different. The learned single judge found no infirmity in the order of the disciplinary authority. The writ appeal filed by the appellant has also been dismissed by reiterating the finding of the civil judge and the finding and by further elucidating as to how the parameter for a judicial review against an order and the criminal proceeding are limited and circumscribed. Being aggrieved, the appellant is an iniquity for us. First, we kindly come to paragraph 11. Paragraph 11 goes, we are also conscious of the fact that mere acquittal by a criminal court will not confer on the employee a right to claim any benefit, including reinstatement. Paragraph 12. However, if the charges, if the charges in the criminal proceeding in the criminal court are identical or similar, and if the evidence, witness, and circumstances are one and the same, then the matter requires a different dimension. If the court in the judicial review concludes that the acquittal in the criminal proceeding was after full consideration and prosecution of the evidence, and that the prosecution reasonably failed to prove the charges, the court in the judicial review can grant reprieve in certain circumstances. The court will be entitled to exercise its discretion and grant relief if it concludes that allowing the finding and the proceeding to stand will be unjust, unfair, abusive. Each case will turn on its own facts. And then Lordship will kindly come to paragraph 28. Paragraph 28 at page 183. May I, Lordship?
Yes.
Expression like benefit of doubt and honorable acquittal. It is not the case. It is not my case, however, Lordship, some relevance are there. Honorable acquittal used in judgment are not to be understood as magic incantations. A court of law will not be carried away by the mere use of such terminology. In the present case, the appellant judge has reported that Exhibit so the original mark sheet carries the date of the so, and the same has also been proved by the witnesses examined on behalf of the prosecution. The conclusion that the acquittal and the criminal proceeding was of the full consideration of the prosecution evidence and that the prosecution, if miserably failed to prove the charges, can only be arrived at after a reading of the judgment in its entirety. The court in judicial review is obliged to examine the substance of the judgment and not go by the form of expression used. Paragraph 29. We are satisfied that the finding of the appellate judge in the criminal case already indicates that the charge against the appellant was not proved. In fact, the charge demonstrated proof by very prosecution evidence. As held by this court, the fact is said to be disproved when, after considering the matters before it, the court either believes that it doesn't exist or consider its non-existence so probable that a prudent man ought, under circumstances of the particular case, to act upon the supposition that it doesn't exist. A fact is said to be not proof when it is neither proof nor disproof. Paragraph 30, Lordship. We are additionally satisfied that in the date of finding of the appellate judge, the disciplinary proceedings and the order bars therein cannot be allowed to stand. The charges were not just similar but identical, and the evidence, witnesses, and circumstances were all the same. This is a case where, in the exercise of our discretion, we quash the order of the Senate authorities and the appellate authority, as allowing them to stand will be unjust, unfair, and abusive. This case is very similar to the situation that arose in the case. Last paragraph, Lordship, 34. Accordingly, we set aside the judgment of the dismissal, so. We direct that the appellant shall be reinstated with all consequential benefits, including seniority, national promotion, payment of salaries, and other benefits. As far as back wages are concerned, we are inclined to award the appellant 50% of the back wages. The discretion, the direction be complied with within a period of 4 weeks from the. Here in this case, I am not claiming for any other service benefits, back wages, but only arrear salary. Because during the suspension period, I've been paid only 50%. So the remaining 50% for a period of 17 months, only 17 months, I'm claiming for that arrear from you. Next, Lordship, 2019 5 ACC. 809.
Para?
So it is a short judgment, only 2 pages. I'm reading the entire judgment. Dear Lordship,
Yes.
Lift conduct. The appellant was placed under suspension on 23/10/1979 while he was working as sorting assistance and railway mail service at Suiso in contemplation of disciplinary proceeding on the allegation of involvement in forged payment of high value money orders. A FIR was lodged against the appellant at Suiso police station, and the case was registered as Suiso under IBC. The order of suspension was revoked on Suiso, pursuant to which he joined duty and worked till 1997, when he was dismissed from service in view of his conviction under Section 409, 467, and Section Suiso IBC. He was sentenced to imprisonment for 3 years. The appellant thereof filed an appeal against his conviction. The criminal appeal filed by the appellant was allowed, and he was acquitted of the charges for the offence under Section 407 IBC. Paragraph 2. The request of the appellant for reinstatement of acquittal was refused on Suiso. It was mentioned in the memo dated 13/6/2002 that the appellant could not be reinstated as he was already dismissed from service more than 6 years ago. The order of dismissal dated 28/2/1997 and the order of refusal to reinstate in service dated 13/6/2002 were challenged by the appellant before the tribunal. The tribunal allowed the original application and directed the reinstatement of the appellant by holding that he shall be entitled for seniority and national taxation of B with agreement from the date of his dismissal till his reinstatement. However, the tribunal held that the appellant shall not be entitled for any back wages for the period during which he was not in service. Pursuant to the order of tribunal, the appellant was reinstated on Suiso. By an order dated 1/5/2003, the senior subordinate of Suiso rejected the rendition of the appellant for full pay and allowances for the period of suspension, that is Suiso. The writ petition filed by the appellant against the order of tribunal by which he was not granted back wages was partly allowed by the High Court. The High Court held that the appellant shall be entitled to full back wages from the date of the order of his acquittal, that is Suiso, till the date of his reinstatement, that is Suiso. The appellant is before us excelling the legality and validity of the judgment of the High Court by which the payment of back wages was restricted only to the period between the date of his acquittal and the date of his death. The learned counsel appearing for the petitioner relied on the judgment of this court in Suiso. To contend that in case the criminal proceedings are initiated at the behest of the employer, and the employee is acquitted, he would be entitled to claim full wages for the period he was kept out of the duty during the pendency of the criminal proceeding. He also submitted that the appellant is entitled to full salary for the period from 1979 to 1987. He submitted that the appellant has filed an interlocutory application seeking the said relief in the High Court, which was not considered. Mr. Rutherford, M.S. Suisu, then Additional Solicitor General, contended that the appellant is not entitled to take wages. She submits that there was no difference between the criminal case initiated at the instance of the employee and one by the police. She also submitted that the appellant was not entitled to any relief of payment of full wages between 1979 to 1987, as the IE filed by the appellant does not find mention in the impugned judgment of the High Court. 5. This court and Suiso Thakur considered the case of an employee who sought back wages for the period he was kept out of duty during the pendency of criminal case for his involvement in an offence under Section 302 IPC. The claim of the petitioner therein was that he was entitled to full wages and is equated by the criminal court. This court rejected the said submission by holding that the question of payment of back wages would arise only in case of termination of service. Pursuant to finding recorded and the departmental inquiry, in the event of dismissal, in the event of the dismissal order being set aside by the court, the delinquent employee would be entitled to claim back wages as he was unlawfully kept away from duty by the employee. This court was of the opinion that an employee against whom criminal proceedings are initiated would stand on a different footing in comparison to an employee facing a governmental inquiry. The employee involved in a crime has disabled himself from rendering his service on account of his incarceration in jail. Subsequent acquittal by an appellate court would not entitle him to claim back wages. Para 6. The decision of Suiso was followed by this court, and Suiso said to refuse back wages to an employee who was initially convicted for offence under Section 302 with Section Suiso and later acquitted by the High Court and criminal appellate. While refusing to grant relief to the petitioner therein, the court held that subsequent acquittal would not entitle an employee to seek back wages. However, this court was of the opinion that if the prosecution is lodged in the behest of the government and the employee is acquitted, different consideration may arise. The learned counsel for the appellant endeavored to distinguish the prosecution lodged by the police for involvement of an employee and the criminal case and the criminal proceeding initiated at the behest of the employee. The observation made in judgment in Union of India Suiso has to be understood in a manner in which the government would become liable for back wages in the event of a finding that the initiation of a criminal proceeding was bona fide or with vexatious intent. In all other cases, we do not see any difference between the initiation of criminal proceeding by government vis-a-vis criminal case lodged by the police. For example, if an employee is involved in embezzlement of fund or is found indulging in demanding an acceptance of illegal gratification, the employer cannot be mulcted with full back wages on the acquittal of the person by criminal court, unless it is found that the prosecution is malicious. Paragraph 7. The point that remains to be considered is whether the appellant is entitled for payment of full wages between 1979 to 1987. The appellant placed under suspension on 1979 and his suspension was revoked on 1987. An interesting development took place during the interregnum by which the disciplinary proceeding was dropped and so. It is clear from the record that the appellant was the one who was seeking postponement of the criminal inquiry in view of the pendency of the criminal case. The order of suspension was in contemplation of the disciplinary proceeding. By virtue of the disciplinary proceeding being dropped, the appellant becomes entitled to claim for salary for the period from the date of reinstatement till the date of closure of the criminal inquiry. Therefore, the respondents took 4 years to reinstate him by revoking the suspension. The order of suspension that is came to an end on 1983, which is the date on which the disciplinary proceeding was dropped. The appellant ought to have been reinstated immediately thereafter unless a fresh order was passed, placing him under suspension during the pendency of the criminal trial, which did not happen. Ultimately, the appellant was reinstated by order dated 1987 by revocation of the order of suspension. Though technically the learned additional Solicitor General is right in submitting that the impugned judgment does not even refer to the IE, we are not inclined to remit the matter to the High Court at this stage for fresh consideration of this point. We hold that the appellant is named fall witches from Sueso 1979 to 1987 after adjustment of the amounts already paid towards cessation allowance. Lordship, last judgment, Lordship 2014 3 GLD 361. Lordship, by filing the affidavit negotiation, the state official respondent raised an objection that against the reinstatement order, the present petitioner did not file any appeal before the appellate forum.
Appellate forum is also there.
Yes. In fact, Lordship, why should I challenge the reinstatement order? After suspension by the order, I was reinstated, so it is not necessary for me to challenge the reinstatement order. Lordship, 2014 3 GLD 361.
Yes.
Paragraph 7. Paragraph 7, 89. 3 paragraphs. The respondent was found guilty of charges in the disciplinary proceeding, and on the basis of the report of inquiry officer, he was dismissed from service by disciplinary authority white order dated 17/11/1988. At that point of time, the respondent was facing trial in the court of the learned additional district judge Manivo, who is for the same charges. And therefore, filing of an appeal against the order of dismissal passed in presence of the criminal proceeding would have served the purpose. The respondent was found guilty of the charge in criminal case, was convicted and sentenced for commission of offence under section so IBC. Therefore, even after conclusion of the trial, the respondent having been convicted, an appeal against the order of dismissal from service passed in presence of the governmental proceeding would have yielded no result. The respondent was acquitted of the charges only on 19/2/2002 when his appeal was allowed and he was acquitted of charges and the judgment and order of conviction and sentence was set aside. Therefore, only after being acquitted of the criminal charge, he preferred an appeal before the Suiso police. This fact has been taken note of by the learned single judge and impugned judgment while considering the delay of 14 years in filing the appeal before the Suiso. Since we also find that the filing of an appeal against the order of dismissal from service would not have yielded any result because of the pendency of the criminal proceeding, both in trial court as well as in appeal, the learned single judge was justified in negating the above condition of the appellant in the impugned judgment. Paragraph 8. So far as the order other grounds taken by the learned so relating to criminal proceeding is concerned, we find the charge in the criminal case was the same as that of the charge in the criminal proceeding. In both the proceedings, same set of witnesses were examined. In the case of Sabra, the apex court held that there is an exception to the general rule that a government employee can be punished for misconduct without being influenced by the acquittal of the same person and the criminal proceeding of the same person in the criminal proceeding. And this little exception may be where the criminal proceeding and the criminal case are based on the same set of facts and evidence in both the proceeding is common without there being a variance. Nothing has been placed by the learned government advocate appealing for the ability to show that there was any variance and evidence in both the proceedings. Therefore, the learned single judge rightly applied the principle laid down and Captain case. Paragraph 9. We also examined the evidence produced both in criminal as well as the criminal proceeding. From the available evidence, it appears that on the date of incident, there was some duel between the respondent and the head constable who got injured in the accident, and after loading the bullet and the service rifle, accidentally the shot was fired, but it never hit the injured head constable. The injuries sustained to the head constable were minor injuries because of and not because of the bullet. Even if we accept this evidence and agree with the government advocate, that such conduct of respondent also amounts to misconduct. There being no intention to kill and bullets having been fired accidentally without causing much damage to the injured. The order of the dismissal from service is also not called for. If any other punishment is imposed, the respondent would have been entitled to patient. In the enduring judgment, the learned single judge, being aware of this fact, did not direct for payment of salary for the period of the respondent remained out of service, and only direct for payment of the patient admissible to him, including in accordance with the relevant pension rules for period of service rendered by him till the dismissal and not till the date of till the date he would have continued in service if he had not been dismissed. Considering all these things, we find no justification to interfere with the enduring judgment whether to be dismissed. So, Lordship, in the extent case also, Lordship, my case is both the proceeding, that is, the disciplinary proceeding and the criminal proceeding are based on the same set of facts. Therefore, in view of the charge of the present petitioner from criminal case, criminal liabilities, he is entitled for at least the area salary, not paid wages, not other service. I'm not asking for other service benefits, Lordship. Only the 50% of my area salary should be paid. Because my suspension is based on the registration of the criminal case. And now finding up the disciplinary proceeding, Lordship, that cannot be done in view of the judgment passed by the Honorable Apex Court in Kohima decision which I've referred to, Lordship.
No, the last judgment which you read out, a
Yes.
difference is made out
Yes.
between, it may be a similar set of facts, but the misconduct part
Yes.
as a government employee,
Yes.
that can be taken up by the disciplinary authority, and he can be punished for that.
Lordship.
Yes.
But then the other
And we have to see what are the memorandum of charges also against the petitioner, what in the disciplinary proceeding.
Yes.
Have you enclosed?
No, Lordship. Only the finding, Lordship.
No, not the finding, but what were the charges in the disciplinary proceeding? That is important.
My lord, in the finding,
I
final
think-
report in my affidavit in opposition, my lord.
Yes, page 8.
Yes,
Article of charges, it's here, I think.
yes.
Yes, see, under misconduct, failure to maintain absolute integrity, lack of devotion to duty, and behaving in a manner unbecoming of a government servant. So that is always there.
For what, Lordship? Allegation of accepting gratification.
No, that is different. That is different.
Yes.
Because that government servants conduct rules.
Yes.
Correct.
According to that, this will
Yes.
come.
Yes, Lordship.
Manner unbecoming of a government servant.
Lordship, may kindly consider one aspect. The allegation is section, Lordship, may kindly see the section. I'm not concerned about the section 14 of IBC, that is differential, Lordship. Section 7 and 13 of the BCA. What is that, Lordship? Accepting illegal gratification.
Gratification.
So based on this section, this article of charge was framed, Lordship. And now all the allegation has not been proved before the criminal court, Lordship. Then how the finding of the disciplinary proceeding will stand, Lordship? Same set of facts, same allegation. So that aspect may be considered, Lordship. And now, Lordship, lastly, I will referring to my
Yes.
prayer only, prayer, Lordship. I made 3 prayers, Lordship. Direct the respondent authorities to withhold salary during the period of suspension, that is 2/10/2018, till restatement, that is 13/3/2020. That comes to 17 months, Lordship. 1 year, 5 months. Second prayer, Lordship.
2/10/18 to 13/3/20. Okay.
To set aside and quash the order dated so. This is the restatement order, Lordship, with petition whereby B and allowances has been denied during suspension period. Only to that part, Lordship. Number 3, Lordship, direct the respondent authorities to restore the agreement and to pay the deducted amount beyond 13/3/2022. Because, Lordship, I made a specific statement at paragraph 12 that the respondent is deducting rupees 2,000 each from the petitioner's salary every month, even after expiry of 2 years. So that aspect may also be considered.
So in fact, you are not challenging the disciplinary proceeding, and you are not challenging the penalty of 2 increments.
No.
You are only
No.
aggrieved by the
Yes.
withholding of back wages.
Your Lordship, I conclude my submission, subject to reply to my.
Yes, Governor Advocate.
May I please, Your Lordship? My Lord, I'll be relying on my para 5, 6, and 7 of my affidavit in opposition, my Lord. My submission will be within this paragraph. So in order to save time, I'm not reading that paragraph.
Paragraph
4, 5, and 6.
4.
5 and 6.
5 and 6.
Yes.
Okay.
In order to save time, I'm not reading that paragraph. But my submission will be within that paragraph. My Lord, in my affidavit, page number 9.
Yes.
Page number 9. Your Lordship, Nagaland annexes A3. By this order, joint inquiry was to conduct joint inquiry was directed to the presiding officer to conduct the disciplinary proceeding against the accused, my Lord. And my Lord, here kindly allow me to read this annexure, my Lord.
Yes.
Whereas a joint inquiry under Rule 10 of the Nagaland Service Discipline and Appeal Rules 1967 is being held against the following 4 police personnel, namely so and so. The petitioner is number 2 and
Here's number 2.
2 and 3. And whereas the undersigned considers that an inquiry officer and presiding officer should be appointed to inquire into the charge framed against him. Now, therefore, the undersigned, in exercise of power conferred by Rule 9, Clause 4 of the said rules, hereby appoint Sri so-and-so as the inquiry officer to inquire into the charges framed against the mentioned above 4 personnel with so-and-so establishment as presiding officer to present the case in support of the charges framed against the delinquent before the inquiry officer. Page 10 is the findings, so report submitted by the inquiry officer. So, Lordship, may kindly see page 12. Page 12. This inquiry report was submitted on 7/9/2019. Page 12. May I read
Page
this part?
12 of your affidavit.
Affidavit, yes, affidavit. Affidavit in the possession.
9,
That is
10.
in 237. Correct? 237.
Yes, 237.
Oh, I'm looking at 238. In 238,
Same.
we are now on 238.
Yes.
So
my lord.
in 238, it is page 11, I think. No, not page 11, page 9, page 9. The presenting officer's final conclusion. This one.
Yes, page 9. Page 9, last paragraph. Based on the above findings, the following conclusions are submitted. May I read, my lord?
Yes.
Number 1, with regard to the charge level against so-and-so, in Article 1 regarding his involvement in monetary giving and receiving for illegal gratification, the delinquent has voluntarily admitted to his guilt of taking money with the promise of employment in Nagaland Police Department. The statement given by the other witnesses corroborates this voluntary admission made by the charge officer. Therefore, it can be said that so-and-so has exhibited his failure to maintain absolute integrity, lack of devotion to duty, and behaving in a manner unbecoming of a government servant. 2. With regard to luring innocent people to buy jobs in the Nagaland Police Department and receiving money to procure the jobs and conniving with offenders to commit the illegal act as given in the statement of imputation of misbehavior, the delinquent has admitted to his involvement and guilt. He has admitted that he has indeed received and gave money for employment in Nagaland Police Department. As such, by committing such an act, the delinquent has caused embarrassment to the good name of the police department. He is serving in and tarnished the image of the disciplined force. Therefore, based on his admission of guilt, it can be established that delinquent has failed to maintain absolute integrity, lack of devotion to duty, and behaving in a manner unbecoming of a government servant in relation to his charge. So, my lord, basing on these findings, the order dated 13/3/2020 was passed. By this order, 2 years of increment, as we
Only
told.
this one article only was framed.
Yes, my lord.
Article of charge, only
Yes,
one.
yes, my lord. And basing on this, the last order, that is the page number 11, annexure A3. And
No,
here,
that is fine. He is also not challenging this.
yes, my lord.
But only that non-payment of his pay and allowances for the suspension period.
Yes, my lord.
Only
I'll
that
come there.
much.
But here he is not challenging the withholding of 2 increments.
No, no.
Yes, he is not challenging, but he is challenging only the. He is praying only to release the pay and allowance.
For the suspension
Yes,
period.
suspension period.
Yes.
So, my lord, here from his submission, it is clear that he is not challenging the decision taken by the disciplinary proceedings. So, my lord, if say by this order he is partly aggrieved.
Partly agreed.
Partly
yes.
aggrieved. So, if he is partly aggrieved, then there is in the provision, because this order and the disciplinary proceeding was conducted under Nagaland Service Discipline and Appeal Rules 1967. In that rules, there is appeal provision to approach the authority if he is aggrieved, partly aggrieved. So, my lord, in the appeal, your lordship may kindly see that Rule 14, my lord. Rule 14, Part 5. May I read?
Yes.
Every government servant shall be entitled to appeal as hereinafter provided against an order passed by an authority, placing him under suspension under Rule 6, imposing upon him any of the penalties specified in Rule 7. That impugned order dated 13/3/2020 was passed under Rule 7, Clause 4. And Rule 16. Your Lordship may kindly see the Rule 16. Appeals against orders imposing penalties. A government servant may appeal against an order imposing upon him any of the penalties specified in Rule 7 to appellate authority specified in this behalf in the schedule. There shall be no appeal against the order of the appellate authority. And Rule 18, the limitation period. Period of limitation for appeal. No appeal under this part shall be entertained unless it is submitted within a period of 3 months from the date on which appellant receives a copy of the order appealed against, provided the appellate authority may entertain the appeal after the expiry of the said period if it is satisfied that the appellant had sufficient cause for not submitting the appeal in time. This, my lord, that impugned order was passed on 13/3/2020. And till now, the accused has not, the petitioner has not submitted any representation before the appellate authority. And the secondly, that in my senior counsel has said that by judgment, by order dated from the law court that his criminal proceeding has been acquitted. That criminal proceedings was acquitted by order only in the year 2024. In the writ petition, your lordship may kindly see, this order was passed on 30/4/2024.
Just come to Rule 17. Rule 17, Clause D. These are the, Rule 17 is appeals against other orders.
Yes, and
Here,
Clause D.
Here, see Clause D, determining the pay and allowances for the period of suspension to be paid to a government servant on his reinstatement, or determining or not such period, determining whether or not such period shall be treated as period spent on duty. So in
Yes.
such circumstances also
Yes.
the appeal can be filed.
Yes,
Appeal
my
has to
lord.
be filed.
So if he is partly aggrieved, then under this rule he should have filed before the appellate authority, and that there is a provision to consider his case. My lord.
After that, if you are aggrieved, you cannot approach.
Yes, my lord.
Just one clarification.
Yes. Because that this alternative remedy is there.
That is there, Lordship.
17D,
Lordship,
clearly,
that-
specifically
Yes, ma'am.
That thought,
on
that thought is clear by the judgment of 2014 3GLD, Lordship.
regarding the appeal provision.
Non-filing of appeal, Lordship. Which I've referred to 2014 3GLD, paragraph 7 and 8. That is one, Lordship. Paragraph 7, 8, and 9. I've already referred to, Lordship. 2014 3GLD
361, no?
361. I've referred to 3 paragraphs. So, Lordship, may kindly consider that aspect.
I think there the facts were a little different.
Here, Lordship, in this case, against the dismissal, a bill was filed only after the pronouncement of judgment by the criminal court.
The respondent was found guilty of the charge.
For that purpose, I refer this judgment, Lordship, to 14.3 CC. Paragraph 7 will clear, Lordship, that out.
No, the court says, since we find that filing of an appeal against the order of dismissal from service would
Correct.
not have yielded any result
Correct.
because of pendency of the criminal proceeding, both
Same
in the
lordship.
trial court as well as an appeal. So
After the criminal court passed
so
order, what
after
happened,
the,
Lordship?
after the criminal court passed the order, you could have filed.
Page 20, come to my registration, page 20, Lordship. This application may be treated as an appeal as well, Lordship. Which is nothing, under 20, page 20 of my petition, 238. This is dated 5/8/24, after the petitioner was discharged from criminal liabilities, page 20 of the petition. That's Lordship correct?
No, but the DG will be appellate authority.
Yes, Lordship. Yes. Against the disciplinary filing,
Yes,
it
Lord.
has to be filed before the DG. So I've always submitted prayer for revocation of the impugn order and for payment of arrears. Very much.
Here you have stated about the arrears during the period of suspension. Then in that case, you dispose of this appeal, treated as an appeal under Rule 17D. Why you have not considered
Yes,
this?
Lordship. And even again,
Yes,
this
this
rejected, Lordship,
letter,
I have to come again
I have no
to
instruction
court.
that whether they have considered this letter or not.
No, if it was considered, the petitioner would have known.
The authority have received on 5, Lordship. On 5/2 itself.
5/8.
5/8/24.
5/8/24.
Yes.
You dispose of this appeal within a month's time. Yes,
Then, my lord, direction may be issued to dispose this representation.
yes.
Yes.
And this will give us a detail about the rules.
Yeah, that's why. We'll give a direction that this representation will be treated as an appeal under Rule 17D.
Yes.
And you dispose it off.
Yes, ma'am.
And you condone the limitation period also, because limitation is 3 months from the date on which the appellant receives a copy of the order.
Yes.
Okay. Yes.
Lordship, in this appeal, Lordship, I have not mentioned about the deduction up to 2,000 per month. Lordship. Should that be also considered, because it is my case in my petition about deduction of 2,000 per month. Lordship.
My lord, that is a different issue, so let him file another representation regarding that one.
No, when it is not here
Yes, ma'am.
stated clearly, then specifically, so you file another one for that deduction.
Yes.
Yes. Mm. The present writ petition has been filed under Article 226 of the Constitution of India, praying for a direction to
Page 10.
page
Very good.
praying for a direction to the respondent authorities to pay the full salary of the petitioner during the period of suspension, that is 2/10/2018 till reinstatement, i.e. 13/3/2020, and to direct the authorities to restore and to direct the respondent authorities to restore the increments. No, not increments. To restore the increments and to pay the deducted amount beyond 13/3/2022. And also for a direction to set aside the portion of the order dated 13/3/2022.
May I please, Lordship?
Yes.
One apology. In regard to prayer number 3,
Yes.
for deducting the amount, the petitioner has not submitted any representation before the authority.
No, that we will. That
Yes,
we will.
prayer.
This is just a prayer portion. And to set aside and quash the portion of the impugned order dated 13/3/2020, whereby the pay and allowances has been denied during the suspension period. Stop. Para. While going, upon hearing the parties, it has been found that there is a provision for preferring an appeal against an order determining the pay and allowances for the period of suspension to be paid to a government servant on his reinstatement, or determining whether or not such period shall be treated as a period spent on duty for any purpose. Stop. Such a provision has been made in Rule 17, Clause 2D, Rule 17, Clause 2, small d, of the Nagaland Services Discipline and Appeal Rules, 1967. Stop. The petitioner has filed a prayer before the appellate authority dated 5/8/2024, praying for review of the impugned order dated 13 March 2020 and for payment of arrears and allowances. Stop. The said representation / prayer has not been disposed of by the appellate authority till date. Stop. Accordingly, the petition is disposed of with the direction to the respondent number 3, the respondent number 3 / appellate authority to treat the representation dated 5/8/2024 as an appeal under Rule 17(2)(d) of the Nagaland Services Discipline and Appeal Rules, 1967, and dispose of the same within a period of 1 month from the date of receipt of this order. Stop. The petitioner, the period of limitation shall also be condoned by the appellate authority in considering the appeal. So, the petitioner is also at liberty to file a separate appeal against the, what was that? Against the against the, you were showing the paragraph
Lordship, that-
regarding the
that aspect-
deduction.
That aspect will not be, Lordship, necessary in the appeal because it should not be by way of
Because
appeal.
this is not against that pay and allowances, yes.
Only the deduction, with regard to deduction, I prayed for this court to release that. So that will not be necessary.
Yes, okay, that can come later then. Okay, then last line, to dispose of within A period of 1 month, no? Okay. Anything else?
No, my lord.
Petitions that's
Limited will be
disposed.
granted the petitioner to approach this court. If
Yes, yes,
agreed by the final
that is always there. That is always there. You can always come.
Line may be
My lord, then that for considering of the representation, not one, kindly allowed 2 months.
2 months.
Yes, ma'am.
Okay, 2 months time.
Yes, ma'am.
The petitioner is at liberty to approach this court if aggrieved by the decision taken by the appellate authority.
Much obliged.
Same order, okay, in WPC 237. But only then suspension order date will be different. Date will be different.
For orders, item number 8.
Your Lordship, I have instructions to appear in the, but it's only in the orders, Your Lordship, today. I have instructions to appear. This is my first appearance, my Lord, for the respondent number 1.
Learned counsel for the petitioner, Mr. Nikato is present. Stop. Learned counsel, Mr. Joshua Sheki is present and submits that he has received instructions to appear on behalf of,
The respondent number 1, Your Lordship.
on behalf of this MSLPSS,
Yes, Your Lordship.
on behalf of the respondent number 1, and prays for
My Lord, kindly grant me 3 weeks' time.
3 weeks time to file his Vaklatnama and to file objections if any.
My Lord.
Lordship, if I may.
Yes.
Lordship, this matter, Lordship, is also pending before the Honorable District and Sessions Court in Zinevoto, Lordship. Your Lordship, in the interim, Lordship, I am praying that proceedings in the Honorable District and Sessions Court may be stayed, Lordship, till the final disposal of this case.
We'll see on the next date since it's appearing only today. Yes. At least after 3 weeks, on which date the interim prayer will be considered.
Obliged, Your Lordship.
From the supplementary cost list, unlisted motion, item number 12.
Oh, that listed one. But petitioner is not there. I'll come back after 5 minutes, okay? 5 minutes.
Me, please, my Lordship. Lordship, the order that was passed by this Honorable Court, the operative portion is at page 231. This was the direction issued by this Honorable Court, Lordship. Can I read out?
Yes, yes.
That is 36.
Conclusions.
Yes, conclusions. Page 36 is, accordingly, this court therefore disposes of the instant batch of writ petitions with the following observations and directions. 1. The appointment which have been challenged in the instant writ petition, i.e. 935 posts of constables who were appointed during the period from January 2018 to October 2019 by the state of Nagaland without advertisement are set aside and quashed. The appointment orders enclosed as annexures referred to in paragraph number 3 of the instant judgment are set aside and quashed. 2. The state respondents herein are directed to take steps for holding fresh selection of the 935 posts of constables by issuance of advertisement in newspaper, which are well circulated in the state of Nagaland. The said selection be held in accordance with law. 3. The process of selection to be completed at the earliest and preferably within 6 months from the date of the instant judgment. 4. The private respondents herein whose appointment have been set aside by this judgment would be eligible to participate in the fresh selection process. 5. The upper age limit of both the private respondents as well as the petitioners herein shall be given relaxation. However, there shall be no relaxation in the matter of basic qualifications as well as the departmental physical criteria mentioned in Annexure A to the affidavit dated 28/2024. 6. This court has rejected the concession relaxation as sought for in terms of Annexure A of the affidavit dated 28/2024. 7. The private respondents may be allowed by the state respondents to continue in service for a period of 6 months from the date of the instant judgment or till such time fresh appointments are made pursuant to the selection directed herein above, whichever is earlier. So this was the direction. After the expiry of this 6 months, Lordship will kindly come to page 236. An IA was filed by the state respondents.
236.
236. IA Civil 31/2025. This was filed, and my lord will kindly come to page 251. The state respondent sought for 6 months more extension.
Okay. That was granted.
That 4 months was granted by the Honorable Court. 251.
Yes.
On consideration of the submission made by the learned counsel for the parties, and also taking into account that the state is taking steps to comply with the direction passed by this Honorable Court. This court, in the interest of justice, is inclined to grant another 4 months time to the state applicant to complete the process of selection as directed by this court in the judgment and order dated 29/2024. The extended 4 months months time shall commence from the date of this order. The extension of 4 months time is granted only for enabling the state applicant to complete the selection process for recruitment to the post of constables. All the other direction passed in the judgment and order dated 29/2024 shall remain intact. It is also made abundantly clear that no further extension of time shall be granted to the state for completing completing the recruitment process for the post of constables in the Nagaland Police Department. This application is done disposed of. So now, after extension of this 4 months, that has already expired, till date, Lordship, there is no recruitment process, and that's why we have filed this
No
contempt.
advertisement, nothing.
Nothing. We don't know whether there is any process. So, from 6 months, 10 months, Lordship, no matter how big, even thousands, within 10 months, time-bound period, they ought to have taken the process and ought to have advertised the post, but they have not. So this is the contempt petition that has been filed by the petitioners. In the second one is also analogous, but that
Now we're on COP 16.
yes, this is 16.
The present application under section 12, 2 clause B of the Contempt of Courts Act 1971, read with Article 215 of the Constitution of India, has been filed alleging willful and deliberate violation of the judgment and order dated 29/2024 passed by this court in WPC. Then there's a whole list of petitions you just see from the cost title, okay? WPC 189/22 and then the others. Stop. I have heard learned counsel for the petitioner, Ms. Zechimomi. Stop. It is stated that by the order dated 29/2024, this court had directed the state respondents to take steps for holding fresh selection of 935 posts of constables by issuance of advertisement in newspapers which are well circulated in the state of Nagaland. Stop. It was directed that the process of selection be completed at the earliest and preferably within 6 months from the date of the judgment. Stop. Thereafter, another IA Civil 31 of 2025 was filed by the state respondents praying for extension of time to complete the recruitment process. Stop. In the said IA
Order dated 23.
31, IA Civil 31 of 2025, by order dated 23/2025, this court further allowed the state respondents another 4 months' time, allowed extension by another 4 months' time to complete the process of selection as directed by this court in the judgment and order dated 29/2024. Stop. It was further stated that no further extension of time would be granted to the state respondents for completing the recruitment process to the post of constables in the Nagaland Police Department. Stop. Where it is the contention of the learned counsel for the petitioner that in spite of the directions passed by this court in the judgment and order dated 29/2024 and the further extension given by this court right order dated such and such that right order dated 23/2025, the state respondents are yet to start the recruitment process and hence there is willful violation of this court's directions. So, issue notice to the respondents.
1, 2. 1 and 2, Lordship, I was informed that Additional Advocate General Imti Imsong will accept. So I will serve to him.
Oh, he said he will accept.
Yes, and respondent, they are in this Zungrengmong festival or something.
Yes.
And for respondent number 3,
And we just say issue notice
issue
to
notice,
respondents
Lordship,
number
Lordship.
1, 2 and 3. Stop returnable within 4 weeks. Stop. The learned counsel for the petitioner shall take steps
Lordship.
for service on respondents number 1, 2 and 1 and 2.
3.
1, 2 and 3 by registered post on 3.
Normally, we will just hand over, Lordship.
Dusty.
Yes, personally.
1, 2 and 3 by Dusty mode.
Lordship, I have one correction to be made. Since we have implemented the Chief Secretary acting, but that acting may be acting may
it
be
is not
wrap
there.
up.
No,
Okay,
it's not
okay.
there.
Okay.
List after 4 weeks. Then
Obliged, Lordship.
next one.
Next one is
Motion
the only
item
order
number
is
13.
on 26. Judgment order is on 26. Passed on 26.
And different WPC. Different
different
Yes.
WPC.
So here also same order, but
Same
the
order, but
order date will be different, and then the WPC number will also be different.
Yes.
Then here also extension. They sought for extension.
all same.
Oh,
Extension, everything is same. Except that a little bit of judgment, there is one paragraph additional is here. That is page 64. No, 64, not 64, Lordship. This is in IA 30. In the previous with petition is, it starts from paragraph 15, page 39. This is covered by the previous judgment order. This judgment order that was passed on 26. These are also
No, we'll only refer to the particular WP number and then the judgment.
All right,
Judgment
Lordship.
order, judgment
Lordship,
date.
Lordship.
So here it is 26/9/24, and WPC is
318.
318 of 2023, and then the extension IA is same. IA is civil 30, isn't it?
All
IA
same.
is civil 30 of 2025.
Yes.
And order dated 23/2025.
Same. Same. Obliged, Lordship.
自己是走的。哎，这只是这样的问，然后他们人什么？不对的是历史的历史过后，历史不是这个就是说你，下一关键就是一个就是对外的问题，一定。我怎么说呢？真难听的，但是这个。人家，说给我实在太早点了。我上来跟你们说，我说了，也是，我知道这是个解释的，这是这是去掉我是实话的，是的。那时候老师怎么是有？我们解释，为啥的什么解释？这样，人会问什么？啊？我完全不知道，我打不进去，我信不过。我说工作忙，工作病，给他逛死了，来不看望这些，来不么？我不得了。反正什么都把我干，我们这边，我。 Hali Kohima.过度区别我给吃的，然后有人闹，跟那个是的，是的，这个人不知道这要干啥。好了。跟人那种，我弄那现在我第一次来这还是给你手外人了，要不本来我是给这去老板啊，人家然后我们这个我就是社区里头不允许非法上搞这种，这个在哪里？这样这要么。然后就是这种法子，你给个人我没钱的，对不对？这个现在这个不是山地上知道，老本事是，这不简单。因为说，是的时候玻璃人吃老麻的，买的不是玻璃煮老麻就是这个光光的这个。我估计也把这个完全了。这什么？这个是专业人了，这个。那是做个小白皮。那个日本人说，人家把不是老头子搞，我是俺们乡里去了。